include your primary residence, or you can have an income of $200,000 over the past 2 years and have a reasonable expectation of making that same during the current year. Regulation D requires that there is no general advertising. This means that you can't have any newspaper ads advertising your hedge fund, no radio shows. These sorts of things are not allowed under Regulation D. And this is probably one of the major drivers of why hedge funds are deemed to be secretive and not really forthcoming. Part of the reason is that hedge funds are relying on this Regulation D exemption, and there's not a lot of very, very clear guidance. So the question is, if a manager says something to a newspaper reporter or someone else, are they engaging in general advertising? And it's one of those very gray areas where there's not a lot of guidance from the SEC, and so to be on the safe side, managers are always very quiet. Regulation D also requires the issuer, in this case the hedge fund itself, to file a Form D with the SEC within 15 days of the initial sale of its securities. And this just means that when you have an investor come into the fund, you'll need to file Form D with the SEC, and your lawyer will probably do this on your behalf. So now we come to hedge fund investors. Hedge fund investors are basically going to differ if the fund is a 3C1 fund or a 3C7 fund. Under the 3C1 fund, you are limited to 99 investors. 3C7 fund, you're limited to 499 investors, again, because of the 1934 Act. In the 3C1 fund, investors are generally going to be accredited investors and qualified clients. A qualified client is a natural person with a net worth of $1.5 million. And the reason that people are going to generally need to, or investors are going to generally need to be qualified clients, is because the SEC has a rule which prohibits performance fees to be paid from those investors who are not qualified clients. So basically, if you are an SEC registered investment advisor and you have a non-qualified client in your hedge fund, you cannot charge a performance fee to that investor. Now, this is going to change based on, if you're not an SEC registered investment advisor, then there may be some state laws which govern when and how performance fees may be taken, and this is one of those issues that you're really going to need to talk with your lawyer about, and your lawyer should know the rules of the state in which you are located. Now, for Section 3C7 funds, you can have qualified purchasers. Qualified purchasers are a higher standard than accredited investors, and qualified purchasers for natural persons are generally those people with a liquid net worth of $5 million. And obviously that's a much higher threshold than the accredited investor qualification. Moving on now to registration. There are two broad registration categories that investment managers, hedge fund advisors need to be aware of. First, there's investment advisor registration, and then there's CTA or CPO registration. With investment advisor registration, there's basically two different ways that it can be done. It can be done at the state level or at the federal level. At the federal level, the registration requirements are governed by the Investment Advisors Act, which requires that, or which says that if you have less than $25 million, you can only register in a state. If you have between $25 and $30 million, you can register with the SEC or with the state. And then if you have over $30 million, you can register with the SEC. Now, of course, there is the exemption still in place. So let's say a manager had $35 million under management, then he could register with the SEC, or he could fall within the exemption. But then the question still remains, does that advisor need to be registered in the state in which it does business? So next we've got so if you do go with SEC registration, then there is that 203(b)(3) exemption like we talked about earlier. And generally, registration is going to take between 2 and 4 weeks to get done. Sometimes longer, depending on a number of situations, the manager's situation. And there are certain items that are going to need to be completed, such as the compliance manual. With regard to state registration, there may be exemptions at the state level, and it depends on state laws. Some popular states, such as California and Texas, generally require managers registered or with a place of business in their state to register as investment advisors. There may be some exemptions depending on the exact nature of the management company and the fund and assets under management, but that will be you'll need to discuss that with your attorney. It really depends on the facts of your specific situation. For some advisors who would be subject to registration in a state, they may want to think about, if they've got the assets under management, registering with the SEC instead of with the state. And one reason that you may want to choose that route is because hopefully the federal regulators, when they come in to do an audit, are a little bit more savvy than the state regulators. It's a state-by-state determination. There are some states who have very, very savvy examiners, and then there are some states who have horribly inexperienced examiners. And then even within divisions, there are examiners who are very good and have lots of great experience, and those who don't. So that's definitely an issue you would want to raise with your attorney. At the state level, you're generally looking at between 2 and 8 weeks, depending on a number of items. Generally, that starts right after the application is submitted, and assuming that all of the necessary items are submitted at the same time. At the state level, managers and important people within the management company generally will need to have taken the Series 65. There are some exemptions out of that, and if you have taken the Series 7 in the past, then you would only need to have the Series 66, which is a little bit short of a test. But I've got some information on my website about the different exams, and please take a look at that if you're interested in more information. At the state level, there's potential net capital requirements. Basically, this means that you would need to keep a certain amount of capital in the management company's bank account, and there are a number of issues dealing strictly with that, and it's going to be something that you'll want to talk with your attorney about. There are also some states require compliance manuals as well. With regard to CTA or CPO registration, basically there's going to be registration with the CFTC through the NFA system. There are some exemptions for hedge fund managers, but there are also some potential state issues if you do decide to go with an exception. So that's something that you would want to have an in-depth conversation with your attorney about, whether or not you would fit within one of those exemptions and whether or not there are state issues involved. Next, there's the Series 3 exam. Basically, all principals and important members of the management company will need